Hello, this is Matthew Chan of the Getty Images Settlement Demand Letter Information website, otherwise known as extortionletterinfo.com. And I have with me Oscar Michelin from New York, who has been our lead attorney and consultant in combating the Getty Images controversy. Welcome, Oscar.
Hey, Matt. How are you? Good to speak to you again.
Yes, it's great to have you. I tell you, there's been a lot of things that have happened since our first recording.
Oh, absolutely.
And we were talking, and we were just thinking, gosh, as much as we knew back then, we know a lot more now, don't we?
Absolutely. One of the things that we know, frankly, is that there are a lot of people out there who have been confronted with this Getty issue, many of whom have either decided to settle on their own, but many of them who have found information on our website that at least gave them some answers and gave them a place to look and get some solace that they're not alone on this issue. And we've had a tremendous, tremendous outpouring of response. And it's really a credit to you, frankly, for having the idea to start this up and get this information out there for people to look at.
Well, I appreciate that. I mean, I wish I could say that it was a totally selfless act, but, as you know, Oscar, my personality doesn't really work well to people who are unreasonable.
Right.
And that's really what I came down to. I was so nice, I was respectful, and tried to do it, and these guys are they're just being unreasonable. That's the word I want to use.
That's basically it. They're not coming forward with a viable way to resolve it. They're taking a very hard stance that's backing people into a corner, and people are either going to have to pay their demands or try to get legal counsel and be ready to fight either litigation or at least through a set of correspondence to try to hold them at bay.
The interesting thing is they have been very successful at this. You and I were discussing about just what we've seen, the scale of money involved, and how many people are paying, and it is clearly a revenue center for them.
We are getting lots of contact from people who unfortunately found our site after they settled and have told us that they wish they had gotten to us before they cut the checks to Getty. So not everybody who contacts us engages in the letter program, but many people are coming to us after they've paid. I mean, I think I was telling you a story before where I ran into somebody at an event, and he had admitted to me after hearing what we were doing with Getty that he had paid $30,000, actually $31,000 to Getty for 40 images.
I about fell out of my chair when you told me that.
Oh, he was having heart failure. And what was worse was his wife was there, and she was giving him the I told you so's because she had said to him it didn't make any sense and that he should get a second opinion. But the real thing that sent it home to me was after he was done telling me, how much money he had paid, he then told me that he had paid an intellectual property lawyer in Manhattan $700 an hour.
$700, jeez.
$700 an hour, and that lawyer had advised him that he had no defense, that Getty was certain to sue, that if they sued, they would win legal fees, and that it could end up costing him close to $100,000 if the lawsuit ever got filed and he lost, so that he should just basically cut and run. So what the lawyer did was work out a settlement with Getty where they had 40 images. They were asking for $1,000 an image, so that's $40,000, and they settled for $31,000. And the guy cut a check, and he was happy until he, ran into me and our website. Because after we spoke, he went back onto the website, and he then emailed me a couple of days later, and he said he couldn't believe it. The information was directly applicable to him, and had he seen this website, he would have gotten a letter for $150 and saved himself a ton of cash.
Right. Well, now that you brought that up regarding what that attorney mistakenly told him, as far as the damages and whether they could win or not, you brought up an issue in one of your posts that most of the images they have are not registered copyright, and therefore they're not seeking statutory damages. Now, can you elaborate a little bit on that?
Sure. I think the key thing to remember is that we are not supporting copyright infringement. We're not saying people should go out and just right-click an image and take an image and not be concerned.
Absolutely not.
What we're saying is there are different categories of damages depending upon two things. One, is the image registered? And two, did you take it knowing that someone had a copyright to it? So with the first part, what Getty had been doing was essentially saying, look, you owe us $1,000. There's no defense in copyright law, to notice or knowledge. I don't have to watermark. I don't have to notify you. You're on the hook 100%, and there's no defense. And if you look at the letters, that's the tone of it. What we've seen from clients who have contacted us is that since we've been up and kind of educating the public, and the public has been responding, saying, if you don't have a registered copyright, you're not entitled to what's called statutory damages. Well, that changes the whole ballgame. Absolutely changes the whole ballgame. Because
a lot of people don't understand that, which is exactly why we're discussing this today.
That's right. If you don't have a registered copyright, meaning you took the photograph and sent it to the U.S. Copyright Office and said, please file this under my name as the photographer and the owner of the image, you don't get two things. You can't go into federal court on a copyright action, and secondly, you can't get statutory damages, which include attorney's fees and costs. So that relegates you to a whole other department now. That means all you can sue for is what's called actual damages. And on actual damages, you're going to get the $49 an image that Getty licenses the images for. Now, if you look on Getty's site sometimes, they even say a year, we're going to charge you $1,500 or $2,000 a year. And so clients have come to me and said, well, wait a minute, why isn't that actual damages? Number one, most of these sites cease and desist once Getty finds out about it, so the image is not up that long. But most importantly, that's not necessarily the market price. And Getty would have to demonstrate that web users on a regular basis are paying them these exorbitant fees, which we're very confident they're not. So we think it's going to be closer to the price point that they advertise, which is $49 per image for a license.
Right. And the thing I would like to point out is that a lot of people are really not trying to get something for nothing. It's just that I think a lot of people that I have emailed are willing to pay something, but they're not going to subject themselves to the exorbitant arbitrary fee. And I believe, correct me if I'm wrong, that Getty, they don't even really know the formula, or they're not disclosing it. It's an arbitrary number as far as we can tell when they come. It's not based on anything that we have been able to come up with.
No, we've seen letters that ask for $1,000 an image. I've seen letters that ask for $1,200 an image. I've seen letters that ask for $1,300 an image. Recently, something new that I've been seeing are letters that are asking for $1,200 and then $200 plus for tax, so that they're charging tax on the images in some letters. Right. Also, we're noticing, and what's important is we're getting feedback from clients who are trying to deal with Getty directly, and in one of them, Getty admits two things. One, they admit that they did not have registered copyright for most of the images. In fact, I believe they had no registered copyrights for any of the images. But in any event, they say they have no registered copyright for most of the images. And the second thing they say, well, because of that they are not seeking statutory damages. So once they admit that in writing, and they've admitted that to a number of our clients now, that means that they're only able to acquire, at best, actual damages.
Right. Now, I want to ask you something. This has been in the back of my mind. In your interactions, do you sense that we know this is a revenue center for them? As far as the collectors themselves that work for Getty, do you feel they're on an incentive program? That's a feeling I have been getting. They seem highly motivated to get some cash in.
Absolutely.
Now, again,
very aggressive.
I want to say publicly that I really don't know. I don't have any evidence. See, the thing is, obviously, I'm in business and you're in business, and then you deal with a lot of people and things like that, and you pick up vibes. And I get the feeling that these guys have an incentive. Now, I don't know if it's a bonus program or if it's based, they're grading them on performance or something, but there does seem to be some enthusiasm, or they're willing to settle, and they go after the people who are most likely to roll over.
Right, and what happens is they treat it as a collection agency would. Now, many collection agencies do work on a commission or an incentive basis, so there wouldn't be anything that unusual about a collection agency working on commission, which would explain their very aggressive, behavior. But if there's anything that we've done that I think has been very positive, is that we've seen a change in the way NCS Recovery, and that is the quote-unquote collection agency for Getty, we've seen a change in the way they operate. When they first started this program, they would write people and say, you're in collection. We're putting you in collection. And this is a debt, and this is an attempt to collect a debt. Well, since we've put up posts and information that, in fact, it's not a debt, it's a claim, and that they can't put you into what's called collection, which means they're going to report it to credit agencies and harm your credit, things of that nature.
Right.
They've now started to say these are settlement demands. They've changed their language. And they don't say anymore that it's an attempt to collect a debt. Now they say this is an attempt to settle a claim.
Mm-hmm.
And there's a really a pair of significant things about that. Number one, the most important is that because you're not in collection, they cannot report this as a debt or a bad debt to a credit reporting agency. And that's what scares people the most about being in collection, especially now with the credit crunch as it is for small businesses, that they're going to have a bad credit report or that they're going to be placed in collection and reported to a credit agency. That could be the final straw that shuts their business, quite frankly.
I'm glad you brought that up. Yeah, I was definitely going to bring up the NCS issue, and you beat me to it. Yes, I'm glad you clarified that it is not a collection issue. And the thing that I would recommend our listeners to do is to review the Fair Debt Collection Recovery Act. Is that what it is? FDCRA?
Well, you can just call it the Fair Debt Collection Act. That's what it's best known as.
Okay, right. And I have read it, and it's actually fairly easy to read, surprisingly, for a little piece of legislation.
Right.
And that way people can know where they stand, what a collection agency can and can't do. Now, to NCS's credit, they do appear to be trying to follow the rules and doing what they're supposed to do. Because I tell you, I have to be honest with you, I was ready to move on them because my prior case I was involved with, I had to deal with a crooked collection agency. You saw that, and it was a mess.
Absolutely. And yes, look, you would expect, Getty's a well-known company.
Yes.
They have lots of resources.
Yes.
So I'm sure they didn't pick some back alley collector. So I'm sure they got a very well-educated, well-versed group of people who know how to properly and legally collect debt. But the main thing that we did was by having NCS acknowledge that it's not a debt and an attempt to settle a claim, the rules of engagement, if you will, are vastly different. For example, in attempting to collect a debt, anything you say can be used against you to collect that debt.
That's interesting.
Okay. However, in settling a claim, all settlement discussion is inadmissible in a court of law.
Okay, you listeners, I want you to hear what Oscar is saying. Say it one more time.
Okay. The most important thing about having NCS acknowledge that it's not trying to collect a debt, but instead trying to settle a claim, is that anything you say to them now is inadmissible in a court of law because it's settlement discussions, and settlement discussions are not admissible.
That is true. That is very true.
In debt collection practice, it's the exact opposite. Once I advise you that I'm attempting to collect a debt, I am putting you on notice that anything you say can be brought up in court. So at the very least now, people can speak freely to NCS and not worry about them saying things like, well, you know what, I'm willing to pay you $100.
Right.
Or, yes, I admit the images weren't mine. And all of these phrases and sentences that you're giving them are not going to come back and harm you in a court of law.
Right. Now, would you agree that based on what we have seen and heard, that NCS appears to be professional, they appear to be respectful in the way they're conducting themselves?
Absolutely, and I'll tell you why. Already now, just from the number of clients that we've had through the website, they've already heard of our firm. So when clients retain us and they get contacted by the NCS, in between retaining us and NCS receiving the letter, once NCS calls and says, we're calling about the Getty issue, once the client calls back and says to them, hey, we have an attorney, it's Oscar Michelin in New York, they back off. They say, fine, that's great. They send me an email, and then they hand the file over to Getty.
Right.
Because they know that we're not dealing with NCS. We won't deal with them. We want to deal directly with Getty. We have offered NCS on a number of cases early on in our program what we think is reasonable settlement amounts. We've said to them, we'll pay you $49 an image. Then we went up to $98 an image. And then finally, one of my last conversations with Karen Fox, who's one of their better well-known agents out there on the Getty issue,
I see.
I said, what if we were to offer 3 times your actual damages? And she came back and said, I'm not authorized to accept that. So I said, well, then you know what? You're going to have to pass this back over to Getty because you're not being reasonable.
I want to insert my opinion here, and correct me if you think I'm off base. The way Getty has been operating, from what I can see, and or there's our correspondence that I've been receiving from different people as well as you have, is they really push the urgency button. In other words, they say, well, if you don't do this, we're going to take it off the table. It's a typical ploy. It's a negotiating tactic, the takeaway. And for me, because I want it to resolve the way I want it, I don't mind taking the time. But they really do play to the sense of urgency. They regularly use the takeaway tactic. What's your opinions on that?
Absolutely. Well, one of the things that many clients who contact me say, well, wait a minute, I need the letter to go out today because the letter says I'm going to lose the offer by tomorrow. You know, or if I don't respond, they're going to take legal action or they're going to put me in collection by 2 days from now, or I think the letter says 14 days. And what I try to tell clients is, you know, that's a random date selected by Getty, which they're not even enforcing. It's a demand letter. It's a claim. They're trying to get you to pay, and they'd rather that you pay sooner than later. So they have to give you an artificial date that does not give you a whole lot of time to decide. And while it's funny because most of these small business owners are very, very sophisticated when it comes to their business. They're either web entrepreneurs, they're real estate agents, they sell wine, they sell yoga online. They do all kinds of very interesting, complicated things that I wouldn't have a single idea about how to do. But when they get a order from a large company claiming thousands and thousands of dollars, they panic. And it's outside their realm of experience, and they try to handle it on their own, and their response is to either pay or to get expensive attorneys. It's going to cost them more than the demand amount. So Getty is putting a lot of pressure on these small businesses to respond quickly, I think in part in hope that they won't look around and try to see what other options they have other than to cut the check.
Right. It just is amazing to me, the tactics being used, because the thing is, there is a pattern. I want the listeners to understand, when you get your letter, obviously you're focused on yourself and what you're doing in your own little world. But Oscar and I have had a chance to really study this on a more holistic level, and we're seeing patterns of behavior and also in the way they communicate. Would you agree with that?
Right, and I think that that's something that the benefit comes through our website, because while we're up to over, I think, 40 now small businesses that have retained us to respond to the letter, we're getting hundreds and hundreds of contacts and communications from businesses, I was going to say all over the country, but in fact all over the world, from Belgium, Germany, the UK, Australia, and of course, you know, throughout the United States, nearly all 50 states. So the pattern is much more evident to you and I because we're dealing with on such a large scale. And they are, in fact, they're stepping up their fees. They're asking for more money.
Is that right?
Yep, they're going to $1,200 an image now. On some invoices, they're applying tax. They are also sending it to collection sooner. So if you don't respond within the 14 days, 2, 3, 4 days after that, it's relentless.
Right.
And professional, but relentless, because they start dealing with it like they're trying to collect the debt. And they start calling and email, faxing, and hounding to try to get you to agree to settle on a number. We've spoken to people. They've been going for about $800 an image. That's the number that NCS is authorized to accept.
Now, Oscar, what I'd like to do is, one of the things that have been very unexpected as far as this website is the amount of international attention. I mean, when I launched this website, I figured I had more than enough work to do just to deal with U.S. issues, you know, in the 50 states. But we are getting a good amount of international traffic. So what I'd like to do is, even though you're not an attorney for none of these countries, I'm sure some of our listeners would appreciate your opinion as far as how this situation applies to them. Would you like to make a few comments on that?
Absolutely, I'd be glad to. We're getting a number of hits and posts on our website from countries all over the world. For example, I've just pulled up the post site now. There's one from Belgium. There's one from the UK. There's another one from the UK. There's several from Australia.
Yes.
Okay. So what happens is Getty has similar programs in all of these countries, Germany, Belgium, UK, Australia in particular. And they're coming to our site, believe it or not, to get information because there's not a similar site in their respective countries. I'm
really surprised. I really am. And they say that it's actually very helpful in their own situations.
It is.
Which I'm pleasantly surprised.
What they like to see, they get the comfort, frankly, of knowing that someone else is kind of championing the cause and is putting up a bit of a pushback. But more importantly, most of the arguments that we make for our law apply to copyright law in the UK and Australia in particular. In fact, the UK has even a stronger law in that you don't get any damages at all if it's an innocent infringement. So Australia has similar provisions as well. So I've been able to help those either callers or emailers or posters go on to some good websites that explain copyright law in the UK and copyright law in Australia, as well as copyright law in Belgium and Germany, so that they can be on better ground. And I think they've been using our position as a model. And what I really like to see is one attorney at least in each of those countries, come on board with a letter writing program like we have, so that we can start getting a response to these Getty issues, abroad and not just in the States.
Right.
Because Getty has a huge program in the UK. I think they started it in the UK before they even started it here.
Right. It's kind of interesting to me. Based on what you have read, you're actually saying that the laws that apply in the UK and Australia is actually more favorable to them than the U.S. laws. Is that what you're saying?
Correct. See, the U.S. law says that if it's an innocent infringement, statutory damages can be reduced by the judge and we have repeatedly tried to make Getty and NCS admit and acknowledge that that's a U.S. copyright law.
Right.
But in the U.K., that number is 0. Not 200 an image. It's 0.
That's interesting.
They have innocent infringement in their statute to protect those who don't intentionally steal intellectual property. It's a common sense approach. Anybody can make a mistake.
Yes.
Anybody can think that something's in the public domain and then take an item and post it, especially an image. You can't innocently steal a song or a movie, obviously. But you can take an image on the website. You right-click, it says save or download, and you're done.
Right.
So everybody in IP is already fighting and screaming over how to protect obviously copyrighted work like movies and TV shows.
Yes.
But for images, people see images on Google Images, and they all automatically believe it must be public domain, so that they're innocent infringers, and that if Getty even had a statutory claim, they're going to be limited to $200 an image at best.
Okay. Just keep in mind, this is his opinion, and you're always best to try to get an attorney within your own country, and perhaps one day someone will contact us and want to take it on, be the lead guy for that particular country.
Right. And I'd be glad to, whoever was to commence that strategy in those countries, to give them an idea of how we run our program here and help them in any way to set that up, because I think it's important. Believe me, I wish I could practice in London as well as Sydney, Australia, and Belgium and everywhere else, but they're going to need to get attorneys admitted to practice in their area.
Yeah, and I just want to point out that what Oscar just made an offer to the international community, I mean, he's just doing that out of goodwill, out of the generosity. I mean, there is nobody that he's going to bill for whatever time he takes to consult with these international attorneys. So that is very nice of you to do that.
No, it's my pleasure, because I think it's the right thing to do and to try to get some response to this. Getty has a letter writing program. We need a letter writing program in response. It's that simple.
Now, speaking of our letter writing program, I'd like for you to elaborate a little bit about the concept of peer review. You were telling me how when you were doing the research, you went through this process. And the reason why I want to bring this up is that, we didn't create this program out of thin air, okay? And we're not, we're actually using brain power here of understanding the issues involved. Would you like to elaborate on the peer review process and what you had to go through?
Of course, the whole website started from the letter writing program aspect of it, from the fact that we felt Getty was taking an incorrect and unenforceable legal position. So that was the initial premise that said, hey, you know what? They're not entitled to these large numbers, even if people did take their copyrighted images. So we started writing letters back to Getty with our legal position and asking them to basically address whether they felt we were right or we were wrong. Getty has not responded. They have not looked at or discussed the content of any of our letters. They've acknowledged receipt of the letters, but they haven't come back and said, we agree with your position on statutory damages, we agree with your position on innocent infringement. Mm-hmm. They've remained silent. So what we did was, which is kind of common in intellectual property and patent law, is we engage in peer review. I gave the problem and the sample to law professors as well as other attorneys in IP and said, take a look at this and tell me what you think the legal position would be. And when they came back with essentially the same or similar to mine and agreed with mine, I showed them our letter and said, would this be an appropriate legal response? And they said, yeah, we think that's good. We would be on board with something like that. And we just wanted to make sure that we were not twisting in the wind,
right,
and that we had a second opinion ourselves. So we have one law professor who's had his whole intellectual property clinic take a look at it,
yes,
and kind of given it its good graces and said, yes, this is an appropriate response. And then other attorneys who have posted and looked at the letter have also said the legal position is an appropriate one. So it gives a certain amount of confidence, of course, and makes us feel that we're on the right track. But, of course, the best response to that also is these letters have gone out months and months ago, our first ones. And I think if we were stating an incorrect legal position, okay,
yes,
if we were stating an incorrect legal position, we would have heard back from Getty. We would have gotten a response from counsel. And instead, what we're seeing is the exact opposite, which we have letters coming back to clients now saying, oh, we're not seeking statutory damages. Oh, yes, we acknowledge that they have no registered copyright.
Yes.
So we've been getting responses to our letters from a side way, if you will, not the direct way, and it shows that implicitly, at least, Getty seems to acknowledge that we're right on the legal issues. One of the posts you can see on the main forum is from a guy who had settled with the Chicago office.
Yes.
And the guy in the Chicago office told him, number one, we generate this number randomly. It's arbitrary. And number two, he told them, we recognize we have no right to statutory damages. So, they're starting to have to acknowledge our position. And I would have thought by now they would have come back with a letter to at least tell us what their position is in response to the points that we raise in our letter. And we're still waiting.
And I think that having researched a little bit of history, I don't really think they ever expected that this would ever hit any attorney's radar or anybody would ever fight it with any particular enthusiasm. And to be quite honest with you, a couple of times I just thought, well, maybe I should just pay it and just get rid of it. But just something felt wrong about this. And so here we are and engaged with Getty. The interesting thing I want to point out to our listeners is that the team that is working for Getty, and I'm not going to disparage them because I really don't know them personally, okay, but they do appear to be very young. I have researched some of these people individually, through Google and so forth to find out what kind of people they are, and they're not even paralegals, to be honest with you. And they don't seem to, from what little I see, they have had very limited business experience as well. So that leads me to believe that they're carrying out the corporate message, if you will. They're the messengers, but they're not decision makers except to the degree that if you fit their number, they can approve it. What's your thoughts on that?
I haven't seen it to have any authority, in particular dealing with NCS, but also with some of the people at the lower levels of Getty. They just send back kind of computer-generated response letters to clients, who are unrepresented. So I don't think anyone of any authority from Getty has, quote-unquote, spoken on the issue. And all we've received, as we said, is an acknowledgement of receipt of our letter,
Yes.
not an acknowledgement of our legal position or a contrary position to our legal position. They might have seen, there have been a couple of recent cases, and again, we post on this as well, that really strengthen our position with respect to, the innocent infringement.
Yes.
There was a case involving Tiffany versus eBay, where eBay actually had been sued by Tiffany's for selling Tiffany knockoffs, and the case against eBay was dismissed because once eBay was on notice that they were selling Tiffany knockoffs and not actual Tiffany products, they ceased and desisted, and they took down their ads and they put the sellers on bad sellers lists.
Mm-hmm.
And the court said right there that was sufficient conduct to make eBay not responsible for an indirect infringement, and they awarded no damages to Tiffany's. Now, trademark law is not copyright law, but it's similar. And that case was it was a federal court case from July of 2008, and right there it showed, even with two mammoth teams on either side,
yes,
that in the end the court said, listen, they ceased and desisted, they didn't know,
right,
you don't get damages. And I think that might also have been seen by Getty Counsel, and they have to take that into consideration. There's a number of different issues that Getty has to deal with before they go to court.
Yes.
And they're going to have to be concerned, just like we would be, are they going to set a bad precedent? Are they going to end up with a judge who's going to disagree with their position? One of the things that I remind clients is if we do ever get into court, and of course no lawsuits have been filed at all yet, I think a court would look at our position as being one of reasonableness. We went out and said, look, we're not saying we want to get off scot-free. We're saying let's pay a reasonable amount under the law. What would the law award Getty? And let's work towards that amount. And if Getty comes in and says, oh, it's all or nothing, we want our $1,200 per image, I think a court is going to look very harshly at that. You're not being reasonable. You're not trying to avoid litigation. So I think we're good.
Oscar, there's something I also want to point out, now that you were discussing that. In one of my verbal discussions, what was told to me is, I said, why are you not issuing a cease and desist letter? Why are you going straight for that? I mean, how is that fair? And basically what was told to me was that it was not practical. In other words, that
there you go.
They have intentionally shortcutted the process. They knowingly shortcut the process. They knowingly don't ask for a cease and desist. They're going for the money because it's more expeditious for them. However, I think that if they ever hit a court of law, there would be a problem. It's like you've got to give somebody a warning. You can't just plop them there and just say, hey, pay the bill.
Absolutely. There's a lot
and they admitted to that as much.
Yeah, they made no attempt to what's called mitigate their damages.
Exactly.
And also, if you look at their biggest competitor, which is Corbis.
Yes.
Corbis, I believe, bought the same program that Getty did. And all they're doing is sending cease and desist letters and saying, if you don't cease and desist, then we're going to ask for damages.
And see, I would say that is much more reasonable, and they're probably not getting the PR backlash that they are on this front. I mean, because I don't hear that much on the Corbis front, amazingly enough.
No, it's been very quiet because they've been doing it, I think, the right way, which
yes.
is if you want to protect your copyright, you give people a chance. Unless, of course, you have proof that they intentionally stole your intellectual property.
Right.
Then the gloves come off. But almost as a rule, all of these people involved in the Getty issue are innocent. They either went to third-party web designers, they bought the images off a CD perhaps, they went to Google Images, whatever. They never, ever believed they were taking copyrighted images. And to a business, every single person, we've had contact of hundreds, by the way, the minute they get the letter, they pull the image. They don't want to fight.
Exactly. I mean, that's been a universal response. No one's saying there, I'm going to keep these images despite this letter. Almost everybody that I can think of has pulled it. I mean, everyone said, I pulled it, it's been removed and all that stuff. Yep. But it is interesting, which brings up another point, that they are really digging into your servers as well. Even though it's not on a web page, there's been reports that they are really mining your server. They're digging around for it.
That's what it does. This program is called PixScout.
Yeah.
And it was developed by an Israeli company. And what PixScout does is put a robot on your website. It has scanned into its database the entire Getty image catalog. And it is now, even as we speak, attaching itself to various websites and looking for Getty images. And when there is a match, it is taking a screenshot of that image and sending it back to the server and then producing this letter.
That's amazing.
Right. So it is a bot that attaches itself to your website and scours the website for images that match Getty catalog images.
What other updates would you like to share with our listeners? I never imagined when we did our first recording we'd be doing a second recording, to be honest with you. But there was just so much new information. I just felt like, okay, we're gonna have to block out a little bit of time and go ahead and make a recording just so that our listeners are up to date. What else would you like our listeners to know up to this point that you think is important?
Sorry to cut you off.
It's okay.
I think that the main thing is you are not alone, and that right now through our website, we've certainly had dozens and dozens, or I think we're up to, like I said, something close to 40 or over 40 small businesses that have retained us to respond with the letter, and also that all of them, at the very least, have obtained the peace of mind. Getty and NCS are no longer contacting them directly. NCS now isn't even contacting us. It's just going to Getty, and Getty so far has not responded. So it gets them off your back, gets them to stop bothering you, and also at least makes you feel you have some solidarity with other people who are in a similar position, and you're sending a message back saying, hey, prove your claim or come forward and respond to our position so that we know where we stand, but we're not going to just roll over and pay you this amount. So that there's been a tremendous amount of popularity on the website, and also we've been retained by those many numbers of people, but multiply that by 3 and 4 as far as how many have contacted us and gotten information from our website and just gotten, if you will, like I said, solace and peace of mind that they now have a way to respond to these letters and to know that their businesses are going to be protected. So I think that's probably the best and final update is that the site is growing. It's more and more popular. Nearly every day, at least an inquiry comes in, and certainly every 2 or 3 days, someone ends up saying, hey, I want the letter, or help me respond with my own letter, or what have you. So it's really been growing by leaps and bounds.
At the risk of sounding like we're bragging, and I have to be honest, I wish I didn't have to brag about this, but I think it's because it's well positioned on Google, and it's one of the very few websites that the parties that are running are very credible. I mean, we're putting our names on there. We're not hiding behind a facade. We're not giving out unfounded opinions. I mean, and we're trying to treat this with the most respect and dignity that it deserves. I mean, we're not trivializing this.
Absolutely.
And we're not name-calling.
Right. And the fact is we're trying to give what's an objective analysis to this issue and say there's a second side to the story.
Yes.
There is a response to this claim that could end up saving you thousands and thousands of dollars because we feel that we're in the legally correct position and that Getty is overstating its position.
Right. Okay.
Just have people just send us any questions or comments. We would appreciate it, and we'll be glad to keep on going with it.
Yes. On behalf of Oscar and myself, we want to thank you, listeners and web viewers, for coming out to our website. This has been very helpful to you, and we really appreciate the thank you letters and thank you notes. Oscar obviously is not getting paid very much, I mean, by an attorney standards, and I certainly am not getting paid a dime for doing this, so the thank yous are very appreciative, and we do like to hear what is going on out there.
Please keep us posted on anything that's happening with you on this issue.
Okay. Thank you for listening, and we wish you luck in the future.